Noa Mendelsohn Aviv is the executive director of the Canadian Civil Liberties Association. The CCLA was one of the organizations to originally bring forward the federal court case against Ottawa's use of the Emergencies Act. And Noa Mendelsohn Aviv joins me now. Noa, it's good to meet you. Thanks for joining us today.
Thanks for having me. Good to meet you.
I'm here at the Federal Cabinet Retreat in Montreal, and people looked a little bit shell-shocked and surprised when this ruling came down. I would imagine you had a very different reaction. How are you feeling about what was ruled today?
It's a historic win. I mean, for CCLA certainly, but it's a historic win for everybody in Canada who cares about rights and freedoms and understand that emergency powers allow government to override rights and freedoms without the usual checks and balances. So we see this as a historic and a very important victory today.
It's not over at this point, it seems, because the federal government has made quite clear immediately that they were going to appeal. What do you expect to come of that process?
And that's going to be up to the courts to decide and to hear it. We think that the decision that Justice Mosley rendered today is, carefully done, and it's, solid. It's reasoned. There are pieces to it that, that we need to consider more carefully as well as we go through it, and pieces that we may not agree with. But ultimately, that's something for the courts to decide. And it's one of the reasons that we have the courts as one of the many really important accountability measures in this country.
It was interesting in reading the ruling that even Judge Mosley himself thought he was going to side with the government when this started, and writes that had he been advising the government at the time, he probably would have advised that invoking the act was the right course of action. But after hearing your arguments and seeing the full evidence, he came down in this direction. What do you make of that struggle that the Judge Mosley had, and can reconcile that with the different opinion that Justice Rouleau had at the Commission?
And that's the role of the courts. And Justice Mosley says it himself in his decision. His role is different from that of the Commission. His role is to adjudicate and consider the legality and constitutionality of, in this case, of the government's decision to invoke the act, to declare a national emergency, to create these new rules that don't have the usual checks and balances, that violate people's fundamental rights and freedoms. And his conclusions can be reviewed by an appeal court, but he goes through, he makes his decision, and he says, very generously to CCLA and the other parties that were involved, that we gave him an opportunity to really consider the very high threshold that was set for declaring a national emergency because of the massive and extraordinary powers that they give to government. And it's very important that those powers not be used unless it really is critically necessary, as defined in that law.
So on that, Justice Mosley said it did not rise to the level of a national emergency, but he does make pretty plain that what was happening in Ottawa was, I don't know if public order emergency is the right word, but a difficult and sort of uncontrolled situation. If the provincial government wasn't acting there and the municipal government wasn't acting there, and all of this pressure is on the federal government to act there, if the Emergencies Act isn't the right approach, how do you deal with something like what we saw in Ottawa in January, February of 2022?
I think he addresses it. I have to go through his decision in more detail. It just came out today, and it's quite long. But essentially, what he said and what we've said all along is it was a policing situation. It wasn't the Emergencies Act or the powers that they created that took apart this blockade of Ottawa, which is a very painful and difficult situation. And we absolutely acknowledge and recognize that the blockade needed to be dismantled. It had gone on for too long. It was causing havoc to residents and especially to marginalized communities in the city. But it was a policing effort that did that. The federal government has recourse to police to bring in other forces from across Canada, all of which is what they did, all of which is how they dismantled the blockades. And as far as I understand Justice Mosley's decision today from the federal court, that wasn't what the Emergencies Act was really used for. It was used for other things like shutting down protests right across the country and getting people's financial information and freezing bank accounts and declaring a national emergency when the situation localized to Ottawa didn't actually amount to the definition that is in the law.
So I know the CCLA, and I believe was it the Canadian Constitution Foundation, if I'm getting the name right from memory, were public interest interveners. And the judge sided with you but awarded no cost. But there were a couple of individuals who were referenced who had their bank accounts frozen, these measures that you mentioned that the justice took exception with. Do you think those potentially open up the possibility of compensation and civil action against the government for the use of those powers?
I don't think it would be appropriate for me to comment on the particular situations of those parties. CCLA came in as a public interest party with our challenge. The CCF came in as a public interest party with their challenge because we had a concern about federal government taking extraordinary powers for itself that take it outside of the normal checks and balances in a democratic system where you go back to Parliament, where things go through three hearings for a bill to pass, back for public input, open, transparent. That's how law has to happen in a democracy, because if it doesn't, all sorts of rights and freedoms can be taken away from all sorts of groups. And we're going to stand up and defend that every time.
Well, part of as a final point, part of the post, invoking process was the Commission as a public accountability mechanism and as an assessment of the Act itself, and there were significant changes recommended there. And now we have this judgment as well, and who knows where the appeals are going to go. What would you like to see come out of this process in terms of changes to the Act, updating of the Act, or curtailing of the Emergencies Act?
It's a great question. I think today's victory really is, first of all, an end in itself. There was accountability, there was a reckoning, there is a message to this government and to future governments: don't overreach, don't go outside of the normal democratic process, because it's dangerous for everybody in this country if you do. So already we have accomplished something enormous today. In terms of the Emergencies Act, there was some question as to what it did, and Justice Mosley today said what we said. It sets a very high threshold before that law can be used, and we agree with him. So there may be some tweaks that could be made to the Act, but if that ruling stands as we believe it should, it's saying governments cannot give themselves massive and unusual powers unless they really have to. The bar is very high. We support that. So we've gotten somewhere very important today, and we're going to continue to fight to make sure that everybody's rights and freedoms are protected from government overreach of this kind.
Noa Mendelsohn Aviv, thank you so much for joining us today to speak about this. As Noa Mendelsohn Aviv, Executive Director of the Canadian Civil Liberties Association. Thank you.
Thank you.
For more on the federal court's ruling today, I'm joined by Paul Daly. He's the Research Chair in Administrative Law and Governance at the University of Ottawa. Paul Daly, it's nice to meet you.
Hi, David. Good to be with you.
I wonder if you can help me reconcile two very different findings, because we have the finding from the Rouleau Commission that concluded the federal government met the very high threshold, and then we have this judgment today that says this was unreasonable and unconstitutional. How do we reconcile those two different findings?
What's interesting about the Emergencies Act, and this is very clear if you go back and look at the debates in Parliament in the 1980s when they were putting the legislation together, they wanted lots of safeguards in place. Parliamentary debates, you remember those from February 2022. They wanted a commission like the Rouleau Commission, and they also wanted judicial review. They wanted multiple safeguards to make sure the Act was used properly. The Rouleau Commission had a very difficult task. It had to work to a very strict deadline. It had to hear lots of evidence and produce a detailed report, all to a very demanding timeline. Justice Mosley in the federal court was able to take all of the evidence that had been presented at the commission, at the Rouleau Commission, and adjudicate on it in light of very detailed and elaborate arguments by clever lawyers who argued the case before him over several days, and he was then able to deliberate very carefully on the whole thing, on the legal and factual context, for about 9 months before reaching his final decision. So it is a much different process than the one that Justice Rouleau went through with his commissioner hat on, and allowed for, I would say, a sober second look at the law and the facts. But one thing is clear, David, that the decision of the federal court is what is legally binding going forward as a matter of law. When a federal government is determining next time whether it should use the Emergencies Act, it is Justice Mosley's decision that binds them and sets the framework, not the findings in the Rouleau Commission report.
Okay, so that's interesting. So for people like me and other people who aren't law experts such as yourself, when we're trying to reconcile this, it sounds like you think we should put more weight on the federal court finding should it hold up under appeal than we should on necessarily the commissioner's finding. Is that a fair interpretation?
I think as a matter of law, the federal court decision is what's binding. Now, of course, that might be appealed to the Federal Court of Appeal. It might be appealed to the Supreme Court of Canada. But that sets out what the legal requirements are. And the federal court can come along and say, you've acted unlawfully. And, you know, if a similar situation were to occur again, you would have the Moseley framework in front of you. And if someone was dissatisfied with a declaration of emergency, they could go straight to federal court and get an injunction to stop the emergency proclamation coming into effect. So that's what matters in terms of the law.
Okay, because you wrote a piece that a lot of people have read about this in May of last year, that justification is central to resolving all of these constitutional issues when it comes to the federal court. So when you look at where we are today, what are some of the justifications that the government failed to present regarding their use of the Emergencies Act?
I think what's really the linchpin of Justice Moseley's reasoning is that when you look at it, when you strip it back to its bare essentials, what you had was a crisis in downtown Ottawa. You had protesters who were embedded, causing all sorts of trouble, making life unlivable for people in the area due to operational difficulties and various other problems with the Ottawa Police and the Ontario authorities. But that does not a national crisis make. And what the federal government had to demonstrate, and in Justice Moseley's view, it could not justify this position, was to demonstrate that there was a national crisis. But as Justice Moseley pointed out, the flare-ups elsewhere in the country, in Quebec, in Coutts, they were dealt with by provincial authorities under existing laws. And so there was no need to resort to the Emergencies Act. And that's really the key finding in Justice Moseley's decision. Everything turns on that this really was a local dispute in Ottawa and should not have been allowed to escalate into a matter of national concern.
So while he says, I think essentially in the ruling it was a public order emergency in Ottawa, it was a local public order emergency and hence not a national emergency. But when we speak to cabinet ministers, Paul Daly, about this today, they point to the economic security of the country. I know the Ambassador Bridge was cleared prior to the invocation of the Emergencies Act, but there was great uncertainty about whether that would stay open and whether there would be attempts at a reoccupation. Why do you think those concerns didn't factor into the decision in the way the government had hoped today?
Justice Moseley has a very careful analysis of what it means to have a threat to the security of Canada. And he was looking at the reasons that the federal government offered at the time. The Section 58 statement, essentially, that it put before Parliament, a fairly detailed document which attempted to justify the invocation of a public order emergency, but which nonetheless came up short on key aspects, particularly the national aspects. It's not just because the economic consequences might radiate out from a local dispute that you have a justification for declaring a state of national emergency, which, remember, is really something that upsets the balance of power between the federal government and the provinces. The starting point in Canada is that most of our rights and obligations are determined by provincial legislatures. It's only on matters of national concern that the federal government, Parliament, is able to legislate and execute the laws. And so this was upsetting the balance. And when it's upsetting the balance like that, you need a very sound justification for doing so. And Justice Moseley, in, as I say, a rigorous, careful, and considered analysis of the reasons in light of the binding legal requirements in the Emergencies Act, came to the view that the federal government's justification came up short.
You called it reasonable, careful, and considered. The government calls it an appeal. What do you think is going to happen there if the federal government is going to take this to the Federal Court of Appeal and presumably, potentially, to the Supreme Court? What do you anticipate might happen?
But first, a word for Justice Moseley, who's a very experienced federal court judge, was someone who worked as a lawyer in the upper echelons of government, very involved in the response to 9/11 in Canada. He's done a lot of national security work over the years, a very serious judge, and he clearly took a lot of time to consider very carefully the implications of his ruling. on appeal to the Federal Court of Appeal, the government bears a burden, a fairly light burden, of demonstrating that there was something wrong with Justice Mosley's analysis. If it can get over that initial burden, just making out a case that Justice Mosley got something wrong, then the Federal Court of Appeal, 3 judges, will step into Justice Mosley's shoes and analyze the evidence that Justice Mosley analyzed to see if his factual and legal analysis holds up. After that, the losing side at the Federal Court of Appeal has the option of asking for permission to appeal to the Supreme Court of Canada. And if that happens, then 9 judges of the Supreme Court of Canada will have their say on the legal and factual merits of this case. I have to say, given that it's the first time that this hugely consequential piece of legislation, which can upend the balance of power between the federal government and the provinces, was invoked, I have to think it's likely that the Supreme Court will ultimately hear an appeal from one side or the other.
Yeah, it certainly seems like the sort of case where the court would want to weigh in and give guidance to everybody in terms of how this should be interpreted. Paul Daly, thank you so much for giving us some guidance on this. That's Paul Daly, Research Chair at Administrative Law and Governance at the University of Ottawa. Thank you, sir.
Thank you so much.